Right. So we are live, and Viraj, I'm really sorry we did take a little bit of time to start. I'm really sorry about that. Thank you very much for being part of the symposium. It's really nice, and I'm really looking forward to your insights. I'm sure it's going to be really interesting. So please, if you introduce yourself and take it from here. This is the one of those rare times when I don't speak after this.
Thank you very much, Vikram, and no apologies necessary. I think the fun that I was having with all your fellow mediators online just goes to show how informal not just our presentations are, but how we are with each other, and we just get along with it and get along with each other. So I'm really glad I got to meet Begum and Yonka this morning. Well, morning here in South Africa, and start this conversation on such a high note after that. So thank you for that opportunity. I would also like to thank you, Vikram, for allowing me the platform to talk about mediation in South Africa. Our dispute resolution system goes back centuries and it has been changed over the years. So I'm going to just do a foundational understanding of dispute resolution in South Africa and our current changes. My involvement in mediation in South Africa. I began mediating as more at the point when it was called alternate dispute. Well, it's still called alternate dispute resolution, but more I chose to do mediation as an alternate to litigation because in one instance where I was in a high court matter of a divorce, and you could see the disparity in terms of financial resources, where the mother and her children ended up with nothing. And by nothing, I mean they didn't have a home, maintenance was not enough. And this was definitely before 2005, before we had our Children's Act that came into play. And I just had to find ways, definitely ways that could bring everyone in to benefit in terms of a process that addresses their concerns. So since 2005, I've been involved in looking for these or researching these processes that benefit people and their outcomes and not the pockets of their legal practitioners. And I stumbled upon mediation. So since then, I did as many courses and qualifications to learn more about the process, the styles of mediation, how to bring mediation practice in all fields. So not just family, but commercial and workplace disputes. And so it evolved into something that became an organization I founded, Fair Practice in South Africa, which is a dispute resolution services organization. But it's not conventional in the sense that we only represent clients and we only offer dispute resolution services. In addition to the dispute resolution services, I promote conflict resolution wellness, where I take that multidisciplinary approach and introduce the clients, potential clients, people who call our practice or call our organization, and speak to them about mental health challenges they may be facing in a conflict. So I work with various professionals in the mental health sector, in wellness, in well-being, to help people understand that interpersonal conflict that they are having within themselves that does not give them an opportunity to communicate effectively or negotiate effectively in mediation. So my practice in mediation continues to grow in terms of looking at the personal circumstances of the disputants equally and fairly, and that we take care, we offer legal care. It's not we're not combative, we're not argumentative, we're not defensive. We actually do care about the well-being and mental health of our clients. In terms of qualifications, I think I've got quite a few, both nationally and internationally. I believe that you never stop learning. One of my favorite quotes is actually from Isaac Asimov, and it says that education isn't something you can finish. So we are continuously learning. I learn from my trainings, I learned from my clients, I learned from my students as well as a mediation trainer. So yeah, that's me in a nutshell, I guess.
So I know you can obviously, there's so much more, but please, if you can start your presentation, and if you want, please, I will not interrupt you again.
Okay, thank you. Well, let me start off by talking about mediation in South Africa, and more in the sense of how our dispute resolution system began, was impacted, and what it is currently. So in mediation in South Africa is very similar to, in terms of like African customary practices, to what your speaker, Adeyemi Akisanya, and I apologize for incorrectly pronouncing his name, your speaker from Nigeria spoke about how mediation and its practice happens in terms of communities and tribes, and I'm just paraphrasing, how that conducted by leaders and traditional leaders and tribal heads conduct mediation. So I align my understanding of African customary dispute resolution practices here in South Africa to what he was saying about the African customary practices in Nigeria and the process, or the informal and flexibility aspects of that process in Nigeria as well. Because the elements in an African dispute resolution remain with peace and empathy. We support these respectful ways of conducting a dispute resolution. And of course, in South Africa, we have that concept of Ubuntu that people internationally and globally, use as an example, as the golden child of peaceful resolution. Which translates to I am because we are. So it's a community-based thinking of bringing in that respect, empathy, tolerance, open communication, open dialogue. There's cooperation and compassion for each other. So when it comes to the negotiation part of the dispute resolution, it's more seen as a compromise in a collaborative environment. So these elements we see also in what we call the Western styled practices of mediation. As mediation trainers, as mediators will know that the foundational part or the ground rules and engagement of mediation is based on respect, empathy, communication, tolerance of each other, and of course, cooperation towards reaching mutual agreement. Now, with the African customary practices, we talk about that culture of respect. And as your speaker in Nigeria spoke about, that respect tends to be, can be distorted in a mediation where that respect is given out of, a sense of fear or hierarchy, if there's an elder in the room. So the mediation itself tends to have a sense of imbalance. And that is just in comparison to the Western style practices of mediation. Now, while that was the practice of mediation in African customary practices, of course, through our history, it would be known that colonization brought about an adversarial system of dispute resolution. And then the people of South Africa, the majority of people of South Africa, were subjugated by the apartheid system, where benefits and privileges were given out depending on your race group. So with these oppressive and unfair practices as part of the South African way of life, and it went on for centuries, it affected the mental health of the majority of South Africans in terms of their ability to speak up for themselves, defend themselves, have access to resources, education. The education standards itself were dictated and dependent on your race group. So access to justice, for instance, if you were given the opportunity, or however slight it was in those times, your opportunities were limited in terms of representation. there was also an oppression of speaking with your mother tongue. So if languages were not according to the languages that were that were noted or made official by the apartheid system, then they were spoken down of. People weren't allowed to even study these languages in school and in educational systems. So that whole oppressive system, it brought about societal fear in terms of movement, in terms of expression. You could be arrested or detained because of this. And that's perpetuated generational cycles of emotional abuse and fear. So part of the South African psyche in terms of not handling disputes appropriately is because of these oppressive systems that, for me, my parents, grandparents, and elders in communities faced and feared. So this segregation of peoples based on their race, which is, of course, determined by ethnicities and cultures, created closed communities where people could only engage with people who were similar to them. And this was part of the legislation in those apartheid times based on what was termed the Group Areas Act. So now people are engaging with each other. There aren't that defined areas that you can operate in, move in. There's no areas of restricted access. However, there is that there's a way of communicating that sometimes gets mistranslated because of tone, because of insinuations, and because of lack of tolerance in most areas. So as a trainer, when I train in mediation and negotiation skills in South Africa, I bring in these cultural differences that we have a myriad of cultural differences in South Africa. It is not just based on race groups. We also have people from different countries that have decided, I mean, we have a beautiful country in terms of our environment, our geographical location, that people would enjoy our weather, our climate, our land. It is all enjoyable in terms of setting up home. And so they've now immersed ourselves in the South African way of life. So when I teach cultural differences in terms of mediation and negotiation skills training, I talk about the cultural differences brought about by geographical conditions, political conditions, economic conditions, and then these then also influence the dignity culture, of independence and trust. Or someone might have a face culture where they look at cooperation and harmony. And then there's the honor culture, but which brings in the element of close ties and strong emotions, which the majority of South Africans do ascribe to. So because of these mixed cultures in South Africa, there is no one size fits all approach to when you meet a South African, because we may be of a certain culture, but geographically, depending how we were placed previously, it affects the conditions in which we grew up. So as a family, in terms of where we are as a family, in terms of South Africans, we are all very different to each other. So it takes time and understanding, especially a perspective understanding, when as South Africans we engage with each other. Now, when we go out into the world and we are introduced to global practices and cultures there, we also, and I teach this as well, have to be cognizant of cultures outside of South Africa. What democracy has brought in terms of our constitution is a recognition also of our 11 official languages. So we are now able to learn different languages and converse with each other openly. You know, it's not restricted anymore. Also with the movement, we can go into different areas and engage with people without any fear of arrest or being told not to be in a certain place. However, there are some areas where there is no tolerance of differences and ethnicities and race groups. And hopefully in time, it will be weeded out. And that's why negotiation skills, mediation skills, conflict management skills training is so important, where people have a distorted view or a very limited perspective on how to deal with people of different cultures, languages, traditions, ethnicities. So I'm just, just as a South African speaking to everyone globally, when you meet a South African, there are no assumptions that we are not able to express ourselves. We are actually quite expressive, and get to know us. We have so much we can offer to the world in terms of how we have progressed through a very oppressive, and I use that loosely, a oppressive state, to now being one where we accommodate each other, we have to tolerate each other. Ignorance has no place in South African communication, because we know what fair opportunity looks like, and we want that for ourselves. So we approach conflict from a point of understanding, and perspective driven. However, I tend to see in my mediations, and I tend to see in terms of how someone identifies from a gender-based point of view, that our cultural upbringing affects the ability to communicate. So when we're faced in a situation where if you've not had access to resources, if you've not had access to empowerment opportunities, to conflict management styles, then those people who are still placed in situations where they have lack of resources to this education and to this idea of that there is something better out there, their confidence levels and their self-esteem levels are low. And that's not their, it's not because they choose to be that way. Sometimes, and we deal with this in our mental health talks and in our mental health wellness programs, where we understand where their struggles are in terms of managing themselves in conflict. So a part of what I work with, and part of what I want to see in South Africa, is confidence when people speak, confidence to use your mother tongue, confidence to speak up for yourself. So while I identify as both Indian and South African, because I'm a South African from Indian descent, my families and my generations before were subjugated to oppressive standards. It is by virtue of my circumstances and access to education that I now know that we have to bolster and empower South Africans to give them that equal footing and understanding of how to conduct themselves in conflict resolution dispute, in conflict resolution management. Of course, there are people who are afraid to speak up. And so our duties and roles and functions as mediators, as people who do have access to the knowledge I have, and to bring it out in them. I run quite a few community-based programs where I go into communities and speak to people about constitutional rights that they have and how they can use them to speak up about any imbalances or inequalities that they face. So as a country, as a democratic country, we do have a long way of going to where there's a sense of equity. Yes, our constitution speaks of equality and fairness and rights for all. However, equity is a problem. We still have approximately only 20% of the population enjoying wealth and ownership of land and access to resources. So mediation has become more pronounced in terms of bringing in voices to disputes that wouldn't normally have had the ability to speak up because of their lack of access to education and resources. What we also have another challenge is that we are a patriarchal society. So leadership rests mainly in the hands of men. and men are default choice for opportunities. So again, creating power imbalances within our society where men are usually seen as the final decision makers, which of course will not work in a mediation setting, because as we know that in mediation, the disputants are the decision makers. So being assertive is another opportunity for people to learn how to put their message across without being aggressive. And I think with mediation, a trained mediator, a well-skilled and a competent mediator allows people that opportunity to be assertive in a safe environment. And a mediator will remove that aggressive stance that people take. And that aggressive stance that was perpetuated by the adversarial system that people call the traditional approach to dispute resolution. So over the past 27 years, since we've become a democratic society, there's been fundamental changes in our political landscape. And there's also been fundamental changes in our legislation, where we could see that this comes through an element of empathy towards understanding people's perspectives. So since we've transitioned to a democratic society, there's been over 37 pieces of legislation that includes alternate methods of dispute resolution as the first step, that being mediation, negotiation, and arbitration, instead of the litigious approach of going to court. So again, where we sit with the rest of the world is that with everyone using the court system as the traditional approach, so to speak, there's been a backlog of cases, trial dates are not readily available, and we face similar circumstances in terms of access to courts because of these challenges. So mediation has come through in these pieces of legislation to guide disputants to go in terms of reaching settlement to a mediator and reach agreement sooner. Now, as globally experienced the public and legal practitioners are reluctant to use mediation, citing one of the constitutional rights, and it comes back to the Constitution, that they have a right to take their dispute to court. So they have access to courts. However, in South Africa, mediators do voice their opinion and say that access to court is always there. What we're talking about in terms of mediation is access to justice. And that means that even though you may not have a third party sit there and make a decision for you, in mediation, you have that opportunity to make the decision yourself. So what is just and fair, that outcome belongs to you, the disputants, and the parties. So mediation practices in South Africa does follow the Western style in some instances, in some areas. However, in terms of family disputes or community disputes, the African customary practices do come in. And our South African customary practices of mediation are acknowledged in legislation. So in particular, our Children's Act recognizes a forum of the lay forums of mediation, which are done by traditional leaders who are given the mandate to bring mediation according to, and I loosely term tribe or customary practices of their culture in that community or that family, to resolve family disputes. So I'm going to just go a little bit deeper into that in terms of family disputes. Our Children's Act makes provision for the focus from an adversarial approach in matters related to children. So that's a brilliant piece of legislation where it brings in not just an amicable approach to dispute resolution, but it also brings in the voice of the child. And makes a child part of the process, not a decision maker, but part of the process. So our Children's Act takes on that amicable problem-solving approach. And throughout our Children's Act, it's punctuated with provisions that bring in mediation. in one section of it, in dealing with the parenting plan or parental responsibilities and rights agreement, mediation is mandated. So parents must see a mediator, and the child's voice must be heard, of course, depending on the age, stage of development and maturity of the child. While in other instances of mediation, the approach is based on the British and American models of process. And here we train mediators to use those models in terms of the process that they use in their own practices. Now, where the Children's Act recognizes the African style of mediation, it also gives the Children's Court the ability to call on traditional authorities to administer the affairs of any group of indigenous people resident within that area. So indigenous people are the majority of the population in South Africa, and they are under the control of a traditional leader. And that traditional leader, again, will conduct lay forums using their style of or process of mediation. What I want to come back to is that these lay forums are not currently structured. There is no legislation that prescribes the methodologies of process. So the customary law becomes a living law, and it is dependent on that particular traditional leader, their hierarchy, their influence over the outcome, their relationship with the disputants, and how it impacts these disputes related to that particular issue. So being a living law, our customary law being a living law, it is not codified and dependent on the social values of that community, which is similar to the unregulated conduct of mediation as it is practiced. It's with here, our mediators are held to a high standard of ethics, and it is suggested that disputants always do their homework before they choose a mediator. With the commonality of customary practices in mediation and the mediation process is based on the Western style of practice, the common elements there are respect and empathy. And wherever you go into mediation a procession or a practice or a process, you should be expected to be treated, it should be expected that you are treated with respect and empathy. Now, in this family disputes and divorce disputes, I encourage a multidisciplinary approach because it brings forward a lot of encouragement for parties to be collaborative. And I think these customary practices that we see in the African communities and in community disputes, they do bring in other people to sit in on these disputes, to give their opinion and their guidance to the disputants on what would be an appropriate outcome, or to consider what would be an appropriate outcome. What I've seen, though, in my own practice is, and taking into account that we are a patriarchal society, I've seen those who are married through customary practice, African customary practices in South Africa, which is recognized, choose to come in to a mediation practice conducted by myself, where I use the process that I've been trained on through the British and American standards of process. And I've seen why this has happened is because women who are subjugated to patriarchy in their communities understand that they may not get a voice in that mediation process as conducted. And I've had clients come in where they want their voices to be heard, so they choose the Western style or an alternate style or practice of mediation instead of the cultural one. And that's not holding anything against them, because as a mediator, I do ask them, what does your customs and practices say? Do they need to go and consult with anyone in their community, in their families, based on hierarchy. How would these decisions play out? How are the children viewed in terms of their families and communities? What do they want? So we bring in that use of our Children's Act, we bring in the use of the process, and bring in the customary practices as their families use and prescribe to. So it's not clean and cut in terms of our bringing in African customary practices in a mediation. Again, it is living, so it evolves in according to the practices of that makes the disputant comfortable. Mediation is seen as an ancillary process right now in our civil procedure to dispute resolution, not an alternative. The access to courts and the access to justice, what I believe should be working hand in hand. And what we see now is a movement towards mediation becoming more of a first step in dispute resolution. It isn't new in terms of the practice currently from the courts. It's always been there with our pretrial proceedings. In labor matters, we have what we call the Commission of Conciliation, Mediation, and Arbitration. We refer to it as the CCMA, which works extensively in a collaborative approach towards dispute resolution in labor matters. So the CCMA was born out of a legal instrument, our Labor Relations Act. And it does prescribe and it does support and endorse disputes moving away from courts, rather using cooperation, joint decision-making, addressing productivity and how it could be increased through collaborative methods. So these previous authoritarian legal systems are being phased out or done away altogether in terms of the new legislation or legislation created since 1994. So the CCMA is quite effective in terms of also reducing court backlogs because it has its own legal system and own court processes through its labor court and appeals there. However, the labor court is not your first step. You have to go through the CCMA processes before getting to the labor court. And that is because there is that culture of promoting fairness in terms of outcomes. So previously, what we had was labor practices that were discriminatory or unfair, oppressive, unequal, based on race and gender. And these are now all addressed by the Labor Relations Act, where you are given the opportunity to use other methods of dispute resolution to voice what was discriminatory, unfair, or just in terms of gender biases or biases in itself that come out in the workplace environment. More of our civil procedure comes out where our magistrates court since December 2014 implemented the court annex mediation rules. However, it was not only designated to certain areas or certain jurisdictions, and it gave, from what I understand and what I believe, a superficial overview of how mediation is actually conducted. It wasn't extensively used. It was there, but not extensively used. What then happened was the High Court became more of an advocate for mediation, use of mediation. And in March 2020, we had our Uniform Rules of Court amended in terms of Rule 41, and we now refer to it as the Rule 41A mediation, where this rule mandates that legal practitioners consider mediation before coming to court. So where should a legal practitioner decide to send summons or notice of intention to defend or a motion to go to court, the court requires, and it's the High Court, the court requires that you would have sent an invitation to mediate in before coming to court. And if you don't do that, then there are consequences to it. The court at the time of costs will ask what were the reasons that mediation was not utilized to bring an earlier settlement or earlier agreement. So Rule 41A, as new as it is, just over a year old, it is starting a movement towards evolving dispute resolution practices. And I don't want to say that there isn't an uptake in it, because what we see from our judiciary is that there's now practice directives being issued. One of which was issued in July 2021 this year from one of our High Court jurisdictions, where the judge president said that there was a possibility that cases will be struck off the roll if it can be seen that there was no consideration of mediation or attempt to mediate these disputes before coming to court. So that evolution of dispute resolution, it is slow, but it is welcome. We will see, possibly, since what the judges are prescribing or directing in terms of this Rule 41A to take matters to mediation prior to coming to court, we're hoping to see an increase in mediated settlements. In terms of how I advocate for mediation, I spent a day yesterday with legal practitioners, explaining to them how they could be advocates of mediation, because we have case law going far back since 1994 that talk of mediation. We have our judiciary that talks of mediation. And what's most notable is the case and a judgment, even as trainers of mediation and practitioners of mediation, that we bring to the attention of disputants and legal practitioners. And that is called the Brownlee judgment. Now, I just want to give a quick quote on how mediation became part of this judgment. And I'm going to just quote the acting Judge Brassey at the time of the case, in which he said that mediation, the benefits of mediation must be recognized, and that the mediation principles and characteristics of mediation must be adopted by legal practitioners in terms of bringing it to the attention of disputants. So he said, mediation can produce remarkable results in the most unpropitious of circumstances, especially when conducted by one of the several hundred people in this country who have been trained in the process. The success of the process lies in its very nature. Unlike settlement negotiations between legal advisors and in themselves frequently fruitful, the process is conducted by an independent expert who can, under conditions of the strictest confidentiality, isolate underlying interests, use the information to identify common ground, and by drawing on his or her own legal and other knowledge, sensitively encourage an evaluation of the prospects of success in litigation and an appreciation of the costs and practical consequences of continued litigation, particularly if the case is a loser. So this judgment is something we use as a starting point in explaining, especially in my mediation training programs, to people who are skeptical about the process, who cannot see the benefits of the process, who think of mediation as therapy or counseling, that no, it is indeed recognized by our civil justice system as a form of dispute resolution. So we are hoping that through these judgments, through the Rule 41A amendments, through bringing mediation through lay forums and traditional leaders, that the people of South Africa can engage in mediation as a first step to dispute resolution. There has been cases, most recently, July 2021, a case where the judge the judge did talk to the benefits of mediation. It was a mediation conducted under Rule 41A, and one of the disputants claimed that it was conducted in bad faith and challenged confidentiality. So this case, Khalafadi Manganese and others versus IDC and others, a 2021 case, sets out the mediation principles of confidentiality and the conduct expected of disputants in terms of good faith versus bad faith. So currently our common law is providing guidance on how the court is interpreting this Rule 41A. It's a long explanation on how Rule 41A works. And it is promoting the use of mediation. So I appreciate that the judiciary is seeing that the respectful manner in which disputants must conduct themselves in their disputes and in mediation is being acknowledged by our courts. So we have, again, a long way to go in terms of giving access to justice to all disputants by we're going on our endorsement of mediation and getting buy-in from legal practitioners and disputants. I don't think we're going to see a turnaround in the next month in terms of everyone jumping on the bandwagon of mediation. I think that is possible where people understand the benefits of mediation. So thank you for this platform to allow me to speak about how in South Africa it can certainly benefit people who have lack of resources, in terms of their socioeconomic status, in terms of their proximity to courts, that they can use mediation to resolve their conflicts. Again, I also endorse that we use a multidisciplinary approach to take care of our disputants and offer them that legal care. And that we as mediators continue to talk about peaceful methods forward. Like countries around the world, we are tasked with having to promote a collaborative approach to dispute resolution. So I appreciate this opportunity to speak, and I welcome your comments on this.
Thank you very much, Veerash. I mean, you've taken us through very interesting areas. I mean, the fact of the psyche, I think that psyche aspect is really important. I mean, all the history, all that, the role that it plays, and interestingly, in terms of dispute resolution, the thought process and everything, I think that's very interesting. I mean, that's something which really haven't heard too much on. The way colonization has affected things, I definitely have seen that. I mean, we've been discussing that. And the fact that, I mean, are we going to go back and see at that point of time when that whole colonization took place, are we going to go back there and start undoing certain things? Psyche, I think, seems to be a very important part of it, which I think you're already doing. I mean, you're doing work on that kind of area of counseling. I don't know what else you will tell us about. So you have already told us. So that's, I think, very important. I think, well, I was thinking on the last day of the symposium, we should just have one little session only on the aspect of colonization, because I am seeing that as important thing.
Yeah, I think that the generational cycle of handling disputes, we need to address how we need to move away from the feelings of oppression that play out in various forms in terms of how people communicate with each other. That lack of actively listening, because you never felt heard, you perpetuate that cycle of not listening. So those forms of oppression need to be addressed. And how do we move forward? How do we address it? Yes, that would be a welcome discussion.
Yeah, and on the other side, this whole concept of the traditional method also having its issues, the patriarchal aspect of it, and all that. There, do you think that some work needs to happen there, and the people who are already doing it there, they need to be counseled or trained? I don't know. Let's not call it training, because no one wants to be trained. But do we need to work there also?
I think the way it is practiced, we need to not change it. We need to understand it. and understand the perspective of how the cultural practices are conducted. Um, Even if that brings in their element of respect and it upholds their hierarchy and the way they conduct themselves and their standing in society, it's not something we can break or interfere with. We need to understand it. And once we understand it, we're able to again, understanding does not mean we agree to it, but understanding it means we are tolerant and less ignorant of cultural practices in Africa and South Africa. So it's not wrong, it's different. And that's why we understand people's differences.
Because what I find important is that there is a structure which is there. There are people who've been doing it, and people trust them. I don't know whether trust them or they don't have a choice. There's lack of choice. I mean, whatever that again needs to be got into. But the fact, like even Mr. Akesani were talking about his presentation, the fact is that there is, I mean, there is a structure, but is it really, first of all, look at it as mediation, or it's more of an arbitration kind of situation happening? And if they change their mindset, if they're doing it, can we actually have a structure available right till the village level? Because that's where things, I mean, I don't know how rural your population is. I mean, I don't know exactly what your statistics are, which we can do a Google search on, definitely. But I still feel that the village or the community is really where the mindset has to change. And you've obviously spoken about that, but what has your experience been on the community mediation part?
So in terms of the community, just to yes, we do have rural communities. That's where most of our population live, and again, that's where that access or lack of access to resources makes anything living sometimes difficult to an extent where they don't have water or sanitation or education. In terms of speaking in line of mediation and how it is practiced in the villages and the rural areas. Yeah, for me, where that comes in, if there's a power imbalance, where in mediation, we know that the decision lies in the disputants themselves. Whereas where it's practiced, where the decision makers are not the disputants themselves, then we have to understand, like you've said, do we call it mediation? Because it doesn't speak to the principles and the practice and the process of mediation. We can instead call it conciliation, where the outcome is determined, where there is that discussion and there is that dialogue. However, there is sort of there is an influence over the outcome by the person that's facilitating it, or the people that are facilitating it. So maybe the way we understand mediation to be and the way we train mediation to be is not the process that is used and should be termed that way in African customary practices. Maybe there's a different term to it. The elements of it, where there's that respect and that communication, and where I don't prescribe that there has to be compromise all the time. I believe in a collaborative approach. But in those ways of the way disputes are run in the rural areas, if there's compromise, then to them that looks like a mediated discussion. We've just evolved the way that discussion happens to a more structured process. And like in my experience is mediating with people from us African customary practices, where women believe that they're not going to get that opportunity to speak freely because of that hierarchy and that respectful silence that they have. They then come to a Western-style mediation practice like mine, where they are given that opportunity to speak. At the same time, not just we are Western-style, but we're also South African-based, is I recognize that there are customary practices that we need to consider. So I go by what my clients, African clients, want in terms of the process itself and where they need to use this style of mediation versus, or in addition to the ones that they go to in terms of their cultural practices. So yes, we would want to have those discussions with traditional leaders and village leaders and communities to bring in how we all can work together so that that aspect of the final decision lying in disputants, of bringing in the voice, of empowering people to be assertive and to speak for themselves, how it shouldn't affect the social standing of traditional leaders, their hierarchy. It doesn't affect them. It doesn't say, because I don't want to do it your way, doesn't mean I disrespect you. I'm going to live with the circumstances. I'm going to live with these outcomes, hear what I have to say, understand my perspective. So I think removing that respectful silence and removing that inability to convey thoughts and feelings and emotions is something we have to work together on.
Yeah, I think this is exactly what I've been looking at, the fact that some dialogue with these people who are tribal chiefs or whoever else is the person who helps people resolve their disputes, to be able to listen to people, the way society has changed, that they should also evolve with it, that their whole, I mean, there is respect, yes, but that respect also should continue. And it's good for them that it continues. So that change is good for them also. Otherwise, one whole structure just might break. So that, I think that dialogue will be important from the people coming in and then having that opportunity. But the gender aspect of it, tell me how important is it that you as a woman being a mediator for these women who want to, who are not really heard, how important has that been?
Well, being a woman doesn't affect my impartiality in a mediation. I do recognize when, and we are trained to recognize where there's a power imbalance based on gender. So where we obviously use our techniques and our toolbox and our toolkits to bring in the voice of women in mediation. So as a woman mediator, yes, I do get biases projected onto me that as a woman you shouldn't be mediating. How could you? You know, you're not a man. Men are the ones who hold these uh, positions of directing and controlling processes. Um, so I face those biases and I face those challenges in the mediation itself. It shouldn't be seen that either the woman is incompetent or is unable to bring parties to reach agreement. I deal with a lot of high conflict cases, so I'm able to move through these power imbalances using my tools and techniques. What I see, yes, women actually benefit from mediation. And I've recently had to explain, my method of using the opening statement to bring in the voice of uh, both parties. So where women hasn't been able to communicate in the relationship, whether it's a work relationship or a family relationship or a personal relationship, what I then do is bring in her voice. Even if it is just at that moment through the opening statement, she feels empowered to speak. So that's where mediation plays a great role in balancing out the input we receive from the disputants.
But how do you see the other side reacting to it? I mean, when you are empowering these women.
Well, they empower themselves by speaking. So how does the well, what that boils down to respect. You start the mediation with respect, and you explain that each person will be, and I don't need to tell you this, but just for anyone else who's listening, is that you start off explaining the rules of engagement and that everyone will be speaking. So when the other person has to hear the one who has less of a voice in the relationship, we have reactive devaluation where they can roll their eyes or shut down or just not listen or try to interrupt. So there is that element of there, but as a mediator, you do pick up on these behavioral changes. And they could happen both ways. So there could be a man who never got to speak in their relationship. Um, or in a relationship, in a work relationship, based on their designation. So how the other person behaves, their physiology, it tells you as the mediator, and it puts up the flags on how to proceed with the mediation. It you do get those people who will interrupt, and I think that's just the way they always handle their conflict. And you, as a mediator, you will use your skills to get them to see that everyone is going to get a chance to be heard, including them. And then you use your skills as a translator, because with that reactive devaluation where they shut down and don't hear what the other person says, you then summarize and paraphrase and bring out what that other person has said. And you give that, you build up that environment of safety and security in mediation.
But have you seen that when such a, say, a mediation, successful or not so successful, but the fact a mediation took place and this people came on the table and the woman, let's here talk about the woman. Of course, men also, like you said, don't have a voice sometimes, but the women being heard and then going back to, be it could be for the villages or wherever they came from, that has it changed things there? Have you seen any change? Have they come back and spoken to you that in their normal life and day-to-day life also there has been a change?
Well, yes, there has been a change. Well, in the one incident, I'm going to speak of this case because it was quite empowering for not just the disputants, but for myself as well, when I understood what was going on in terms of going back to their families. So both of them had come from two different villages. And I again use that very loosely and not in a derogatory way at all. But it's not my intention. They came from two different tribal backgrounds, and they could not. The reason why there was a breakdown in the relationship is because she had now become an educated woman who now had a designation in her workplace where she was in charge. Yet when she went back home, she was treated as someone who didn't have a voice, who had to be very domesticated in terms of her duties and roles and functions. And she had no decision making powers whatsoever in terms of her children. So when she came into mediation and she brought these concerns, because she was silenced, that in that mediation process, that was the first time her husband heard of what she was struggling with. So he went back to her family and spoke on behalf of her to her family and say, "You have to listen to her. I understand that I'm the husband. She understands what she's struggling with, so you have to listen to her." Because mediation brought out, it was used for her to speak, and we did it online. So she was actually speaking to me online. It was a joint session. And by virtue of her speaking to me, he heard what she said. And that's not how she knows it to be when they're in the city. That's not how he knows it to be. So going back to their families, he explained to them who she is, her designation, her responsibilities, her role. And they may not have agreed to it, but they understood that she was not going to prescribe to these roles and functions that they were giving to her, because she'd moved on from there. So they did come back and did explain to me how, because he heard through mediation what she was facing or going through in terms of her family, he then went back to her family. And despite them going through a divorce, he went back to her family and explained to them that they need to respect her more.
So basically, social change can happen because of mediation and mediators. Because I had did a little, okay, but it was just one episode, but the whole concept was role of mediators in social problem solving. So I think that part of it also needs to be brought out as we go along. I mean, this is one symposium. We'll get into those aspects, but I think this seems to be a very important part. So at least that's one step that someone could take and the other side person could understand the larger implication of what things are. It's not just that particular issue, but the larger thing. So I think that is important. But tell me, in terms of private mediation, as we call it, look, I don't like to use the word private mediation. For me, every mediation has to be private. The court system, I'm a major critic of it. I know you are still you're talking about it. We'll come to this. We'll come to it later. But in terms of what we call private mediation, as or mediation as it should only be, what is the structure there in terms of the law is there a law regulating it, and how does it work?
Well, disputants can engage in private mediation, and I think you understand. We both understand that to be in terms of going to see a mediator outside of being mandated by the court to do so. Or it could be that they go to prior to even seeing legal practitioners, which you can do. Our systems do not stop you from doing that. And in fact, yesterday when I spoke to legal practitioners, I actually told them that before you even consider going through the court processes, go see a private mediator, start the mediation process. Don't be bogged down by the 30-day rule and the 15-day rule on when to reach a decision, or to have these days hanging over your client's head saying you have to reach resolution in 30 days. And if you don't reach resolution in mediation in 30 days, the mediation was a failure. So what private mediation does, and what I see here with my own practice, is it gives the disputants time to reach that emotional state of collaboration. It starts off with them defining the issues. And sometimes they're not on the same page as to the issues, where one would have thought, no, I thought we settled on that, or agreed on that, or I thought, we agreed to do this and that and the other. So the process itself starts off with the parties or the disputants coming in, and if they haven't even got legal practitioners, then I refer to them as my clients, because they come to me first, is that they sit down or now virtually and discuss what are the issues we're going to be mediating on. Of course, the agenda is not cast in stone. You can always add or remove agenda items. And then they progress at their pace. So depending on homework they might get or the reality testing they need to do on decisions that they've come to, they work at their own pace. And then they may go and get a legal practitioner involved if, depending on the complexity of the dispute, or they need to take their memorandum of understanding to be made a court order, or they want a legal practitioner to advise them. That's all open. Again, we haven't yet served legal documents. So there's no prescribed time hanging over their heads to get this mediation done. I hope I've answered that part of your question.
Yeah, but I'm just saying a little beyond that now. If these people do, I'm calling it private mediation. I don't like that. This is mediation. It has to be before the court even comes into the picture for me. That's what mediation has to be and has been, that kind of thing. But I'm just saying now, at the end of this, they do get into a settlement agreement. What is the status of that settlement agreement? Is it just a contract or anything beyond that?
Again, they're dependent on the field of the dispute. So in terms of a commercial dispute, I prescribe that the mediator does a memorandum of understanding. So you do have the legal practitioners that do get involved in terms of refining the details, time limits, service expectations, consequences, and they work in collaboration with the mediator in terms of getting down to the final details that need to go into that memorandum of understanding. What then happens is that the mediator now does not become a legal representative and takes that document to court and make it an order of court. Instead, the parties themselves sit in the mediation and determine, okay, what happens to this document? Which one of us is going to make it an order of court, or do we go together and make it an order of court? And making it an order of court then means we're now bound to following through on these contents of this converted settlement agreement. Again, it boils down to what the parties want in terms of that, but as a mediator and in practice, I do draft memorandum of understandings. I do draft the parenting plan or responsibilities and rights agreement according to what legislature requires needs to be as a basic structure of the document, and we incorporating the voice of the child. And then in workplace disputes, where you're mediating workplace disputes, if there's no written outcome necessary, there is a report on what was agreed upon. So there's various ways of how the mediation comes to an end. I know that as a mediator, you don't take the document yourself to court and make it an order of court.
Well, I'm just trying to understand. Look, the thing is that, of course, you made a different distinction between mediation and conciliation. Although the way I look at it is because the word conciliation came into use because in our case we've got a law which is called conciliation. It's part of the Arbitration and Conciliation Act, but don't consider it connected in that case to consider arbitration, but we have a law on conciliation. Now that was because UNCITRAL was using the word conciliation. It made a model law on conciliation and we adopted it. We took it from there. So we have that. Now thing is that if you follow that process in that conciliation, becomes a court decree, the settlement agreement. So I was just looking that aspect. Is there talk on creating that kind of a structure, legal structure, where parties are getting a court decree the moment they enter into that settlement agreement?
So in terms of conciliation, it is recognized by Labor Relations Act. And yes, it is that practice of getting people to reach an agreement, and it does get taken and converted into an order so that they can have an understanding of what their responsibilities are. So we push for people to, or we suggest to both parties that take this document and turn it into a court order so that you can hold each other to it. You don't want a prolonged state of conflict. You don't want that. So make this into an order of court, and then you can follow through on that. There's no necessity if there's an agreement that we've come to an understanding. However, if it's complex and if there are finer details and you both want a blueprint of how to go forward, then make it an order of court. It's a safer choice.
But I'm saying, Veerash, please push for a system where that settlement agreement becomes directly a court decree. You don't have to go to court, because I'm saying that the courts have to be thrown out of the whole process, because definitely there's some issue somewhere, because if you have to then go into court and then go into mediation from there, there is some channel that has not been created between people. So I'm saying a law like that, but of course that law has to be flexible enough that the parties decide who the mediator has to be. Don't give them certain qualifications or whatever accreditation certifications, because then again you're limiting the choice of the parties, which themselves have to trust the person. You can't limit that part. So there are lots on that we will definitely have to discuss, because as I understand, that law is not there right now in South Africa. I think that needs to come up, because when it comes down to the signing of the Singapore Convention, because of that, at least there is a conversation happening on drafting a law in some countries. Like I said, we already have a law which people keep saying that there is no law on mediation in India. We have a law, it's called conciliation. And I told you the reason for that. And that aspect, anyway, UNCITRAL is clarified in the new model law. That's just the same thing. We were using that word. But at least that discussion on mediation has happened, which is, I think, a good thing. But South Africa, is it a signatory to the Singapore Convention?
No, it's not. And to just go back two steps before what you're saying is, I think with the way we are endorsing mediation and the way the judiciary is looking at it right now, we want parties to come to mediators, to see them as professionals of dispute resolution. Right now, they're seeing them as therapists or counselors, or a weak approach to dispute resolution, and it's not. It is a legal process. The mediator does have legal information and knowledge. So you don't need, and I do say this to people who do contact us, is you don't need a legal representative to be in mediation. You don't even have to go to the doors of a lawyer to come to mediation, even though mediation is a legal process. You start taking responsibility from that first step for the outcome, and only when needed, and the mediator will guide you on this, do both of you go and see a legal practitioner. Don't start a fight where there actually wasn't one. So where they can reach resolution by themselves first, by all means, go ahead and start mediation before even opening the doors to a legal practitioner.
Well, I tell you how I'm looking at the whole concept of the courts coming in and how they are going to affect the whole concept of mediation. I always give the example of the US, and you will hear this a lot of times, but I will keep repeating it. The whole concept of 40 years of mediation in the US, and there's a lot of discussion on that, and the American model and everything. Today in the US, 100 million cases are filed in courts every year of a population of 300 million. Imagine how many and here we talk about mediation being there. So there is now why are cases going into courts and then going into for ADR. I haven't got the statistics on. They say 90% of them don't go for trial and they are resolved through ADR. And how much of that is mediation? I don't have that statistic. I'll have to look for it if I haven't been able to find it. But I'm just saying that the fact that parties take that route of going for litigation, they're in the control of lawyers. So mediation in that country is in the control of lawyers. The matter is filed in court and then the lawyers are making their money as mediation advocates. That is why mediation is happening in that country. The mediators by themselves otherwise don't have work. The court system is giving them nothing. There is just that hope for them that some lawyer will identify them and then use them for a mediation otherwise, but that otherwise is not happening for them. That's the way I understand the situation. So I'm just saying that this whole court related thing, which is you are of course looking at that as happening in South Africa, and there is something on mediation which might happen. The profession will never develop because of the fact the court has a self interest to clear its backlog. It is never going to let the mediators charge market value. It is not happening anywhere in the world. So if they are not going to be charging market value, what you have told parties is mediation is almost free. I'm still calling it free, but almost free, and it is connected to the courts. So tomorrow when you are trying to develop your practice as a private mediator, again I'm using the word private, I don't like to use it, but I'll still use it as a private mediator. How do you do it? How do you explain to them that look, you have so much experience and there is a charge to be paid for it, that you have to pay this for mediation? Because their concept of mediation, if it develops through that system, is never going to be let us pay good value for it. We should not go to a lawyer, and if because a lawyer, for some reason their lawyer's fee is acceptable, although the person is not actually helping you resolve, but taking you through a process. And that process, of course, the court system and the issues with the court system, I don't know, you'll have to tell us about court system in South Africa, number of cases, time taken. Of course, you'll take us through that. But the fact is that you are putting through a whole channel where over time, look, we have to have a long-term vision on this. If we have to develop mediation, for me, it has to happen outside the court system. And the court system is always going to be a hindrance to it. So how do you think it's going to work?
For me, I believe that once mediation becomes regulated, where there is specific legislation that speaks to mediation itself, and mediators are recognized as a professional with a professional body overseeing mediators, and it becomes known that mediators are people who work, charge fees, and give themselves off professionally as dispute resolution practitioners. That's going to be. We have to look at models around the world where, in countries where they've mandated mediation, our disputants are actually going to mediators, where they've created some form of regulated mediation. Is it actually being used? In South Africa, the most that's come down to cost being placed in regulation is that the parties share the costs equally. It doesn't give specifics. We do have the court annex mediation rules that prescribes a certain fee of a court annex mediator, but does not prescribe a fee for, well, as you would term, a private mediator. So the court annex mediation costs are a guideline of what people should be paying in mediation, and then says that same fee gets divided or shared equally in terms of cost to the mediator. Now, what legal practitioners need to note, and in South Africa, they've certainly noted it based on that Brownlee judgment, because that judgment, what the acting judge did was, when he had given his judgment in terms of failure to use mediation, he limited the costs that the attorneys could recover from the clients. So he brought to the client's attention the amount of money they could have saved had they attended mediation. And that happens in my own practice as well. When legal practitioners are being obstructive to their clients in mediation and are trying to convince them to leave mediation, to come back to going the litigious route, I do remind the legal practitioners jointly, and I do call them into a session about that judgment in Brownlee, where the court was of the view that had the parties attempted mediation prior to the commencement of court proceedings, and the legal practitioners have a duty to inform clients of using mediation, that their costs could be affected, both parties or one of the parties, their costs could be affected through the courts. So now that people are starting to see these backlogging cases, of course, they didn't have access to courts as freely as they would, or to put matters to court as they could during the lockdown. People are now looking for these alternate methods of using mediation. And of course, where we have, it is that mentality to go to an attorney first. The attorney is going to win my case, that winner takes all mentality. And an attorney is going to win my case for me because I don't want to take responsibility for the fight. So a mediator is going to force me to take responsibility, and I'm not mentally prepared to do that, especially if they have a mentality that says, I'm not the one at fault. I'm not the one to blame. So I will throw money at someone who will make me look good in a fight, instead of being in a conciliatory or in a collaborative method where I take responsibility for being the final decision maker. What I see where there are those power imbalances is that the one who believes that they're the victim of a dispute, or they're the victim of what is happening right now, in terms of the consequences and circumstances that brought them to a breakdown of a relationship or loss, economic loss. They don't want to be honest about their role in that dispute. So they want someone to or understand their own perspective in causing that dispute. They want someone else to make them look like the good guy. A mediator is not going to do that. A legal practice, your lawyer will do that. That's what they're there for. So there's that mindset shift to being more aware of your role in a dispute, so that you can communicate effectively in terms of what your concerns are in terms of that outcome. And as you know, that's what we mediators do. We go down to those concerns. Why are you not putting offers on the table? Why are you not accepting offers that are on the table? Tell us what's going on. And that makes people uncomfortable. A fight does not make people uncomfortable. The fight, they'd rather pay to fight to not feel the discomfort mediation brings out in them. So that's my view of why people choose to go to lawyers first. What I did speak about yesterday was when that happens, when parties do come to you first, and as a lawyer, you have that responsibility to analyze the case with your client and go through that risk analysis and be honest with them if they're a losing case, that their chances in court are not going to give you a better outcome if you mediate an agreement, but if you come to a joint agreement that benefits both of you. We call that the worst alternative to a mediated agreement. And legal practitioners need to be honest with their clients that the better alternative is to stay in mediation instead of going to court. So I think that comes down to mediation advocacy, that legal practitioners, when they see clients coming to their doors, let's actually analyze and prepare a negotiation strategy to go into mediation, which doesn't take away from the skills of a legal practitioner. It doesn't take money away from a legal practitioner, because you're still spending time working on your negotiation strategy with your client. You just have to be an effective negotiator.
Well, I mean, this is my take. I will take, you will, of course, whatever you think about it. It is a colonial hangover that we have, that dispute resolution and courts are connected for whatever reason. I mean, it's in the psyche. It's over time. It's been conditioned. We've been conditioned on that. But for me, courts are one route for dispute resolution. Yes, you have that option. It's put down. There's a constitution which gives you a judiciary, and it gives a lot of things that the judiciary has to do. And dispute resolution between private parties, constitutional judgments, certain criminal matters which need to be looked at because it's a crime against society kind of thing. Yes, a lot of roles to play there. But dispute resolution is not only connected to courts. Dispute resolution has to happen amongst people. It is not even connected to lawyers. Dispute resolution and lawyers' involvement for some reason seems to be a direct connection that people make. No, lawyers are there. They have a certain knowledge of the law. If it is required by people who want to resolve anything and the legal aspect has to be looked at, yes, you can take the help of a professional, like you would can take in a certain kind of a dispute where you need to get an engineer involved, a chartered accountant involved, you can get a lawyer involved. For some reason, I don't know why we've got this concept. So this hangover, colonial hangover needs to be, and that is why I keep talking about this whole traditional thing, that there is a different route there to dispute resolution. That's one part. On the court system, I mean, you'll hear this again, I'll keep again say it. I feel that courts should put a board outside, at least in countries like India, where the backlog is huge. You have 43 million cases lying in court. You have the number that go in and go out is the same every year. So 43 million stays there, and there are people involved. These are people, individuals who are affected and their families affected. So why not put a board outside the court that we deny justice? Because justice delayed is justice denied. Enter at the risk of your money, time, and peace of mind, and then let people walk in. And once they walked in, then it is what you were supposed to do, which is dispense justice through a decision that you take. Like you said, people want you to take a decision. They do not want to take the decision so yourself. So they walked in there. Now, because you could not do your work, because maybe you did not have enough judges, or maybe whatever your reasons are, because your procedural law is such that you've, like in India, we've still got the 1908. We got independence in 1947. We've got a 1908 civil procedure code. So can you imagine what the hangover, the colonial hangover, and the legacy we've carried forward? So this is what's how the court system works. Now, if you at this point of time when the person has come to you, you force them to go into mediation through this aspect of costs, like you were saying, the Brownlee judgment, one, or we create a certain law, like we in the under civil procedure code in our country also there is a concept of mediation. So whatever way you're forcing parties to do, I give the example that a village or villagers go to the government and say, please make a road to connect our village because we don't have a road. And the government says, no, you must make the road yourself, and forces you to make the road yourself. No, your government was, you were given a certain responsibility under the constitution. You were supposed to do it. Same way judiciary was given a certain responsibility, but forcing them to go for mediation is like forcing the villagers to make the road themselves. And if you don't make the road yourselves, there will be costs on you because you did not make the road. Can you imagine? This is exactly what mediation through the court process is. I don't see any difference in this. It is a diametrically opposite way of dispute resolution. It has nothing to do with the court system. Why would you want to force people to do something which they did not come to you for? Only because you have a backlog? You, and let me give you an example how it works in India. I mean, I don't know South Africa, how's it taking it. So a matter, if it has to be sent for mediation, it comes to the court and the judge decides whether this is a fit matter for mediation or not. So first, parties are spoken to, that you have a choice. You have a given ADR choice. So under that, you can go for mediation, the conciliation, arbitration, or we have a people's court concept. So now this is a judge looking at all these options and asking the parties which option you want to take. I won't get into specifics on how the options work, but there is a time taken of the court. What I say is that there is a person languishing in a jail somewhere. He's innocent. Maybe let's just say this. There are people who are innocent also who are in jail. Obviously, not all guilty people are inside innocent. So if for 1 hour also, if say for 1 minute also, an innocent person is sitting in jail, and the court is spending its time to counsel parties to go for a process which they did not come to you for, I think it is actually injustice to that one individual who's saying, today my matter will be taken up. Today I might be able to get out of the jail. I might get justice. I don't think they have been able to understand that. I think they've got into this bubble of theirs that for them it's a case number. Okay, case number so and so. I have to in some way clear my backlog. Where do I send this person? Okay, go for mediation. Why? I mean, I'm saying that court annex aspect of it, it might be something that you're looking at as something which might in some way promote mediation and the concept of mediation. I am saying it's not going to happen that way, but even if it goes that route, but the route has to be through a person who has to spend time in jail because the judge had to take time for a divorce matter to do the counseling for them and to explain to them the benefits of mediation. I think we've gone wrong somewhere. Now your take on this. I'll keep quiet on this now.
Well, I think it's a change in handling disputes. I mean, I pick up that, yes, I agree that people have now become just a case number in the justice system, where there's a lack of empathy shown for what happens to the disputants after or during the process of dispute resolution. There's a lack of sensitivity to their personal circumstances, and they just get treated just as you say, a case number. And that's just a failing of society. And whether that's a failing of society and how we've been programmed to deal with each other, I mean, we can see that failing of society on social media. So we have got to change the way we conduct ourselves with each other, towards each other, our conversations, our communications towards each other needs to have that element of empathy and understanding. And we seem to have, well, we have certainly lost it when our cultures became affected through adversarial systems, where that ability to speak to each other as equals was affected through these adversarial systems. And the way, well, in South Africa, our history can clearly show you that the inequalities have affected us speaking to each other with tolerance and empathy and perspective. So I think what's happening now is that the movement of mediators coming out, mediation, conflict, mediation practices, conflict management, peacemaking, just looking at all the other global institutes that organizations that talk about peacemaking, we're moving towards a different culture globally, a culture of recognizing each other as human beings. And that is going to mean we are going to break the mold of the systems that are currently in place. And I think because you and I and all your speakers and members of global organizations see, and I'm a member of ADR ODR International as a South African representative, and I can see from having to deal with other country representatives that we're getting frustrated that it seems to be moving very slowly when we can see the benefits of collaboration because of these legal systems that are ingrained in people that a court needs to make a decision for you. So our frustrations are that we're not acting unified in terms of reaching resolution, in terms of the best interests of clients. And lawyers are not client-centric. They are monetary or value added to themselves centric. So and that there's a handful that I must say are not like that. They are client centric. They've put the effort to come to mediation training, to come to negotiation skills training, to see how they can maximize value for their clients. And many of them who've come to my mediation and negotiation skills training have retained clients because they give that understanding of a collaborative approach. And that's what makes the clients happy, is that you understand me, you've heard me, you know what's in my best interest. And we're going to see that, and I can see that now with university students, people I mentor, and seeing all these global, like yourself, global conferences of speakers, where we're starting to influence, even though it might not look like we're moving mountains right now, but pebble by pebble, we're moving that conversation towards collaboration, towards listening. And what I enjoy is when we're starting to use concepts of saying, of when we speak to other people, you may be listening, but are you actively listening? Questioning people, do you not know the difference? Because let me explain that to you. And that just opens a whole new dialogue of, are you actually paying attention to what I'm saying? And what I'm seeing in terms of empowerment with people who weren't given a voice before is they pick up when someone says, with all due respect, and they question, but are you being respectful because your tone is saying something else? Is that they pick up communication in terms of where people are not giving them that personal touch in terms of addressing their concerns. So legal systems right now are frustrating us. What I see in South Africa and in the last few months is with these rules and civil procedure changes that the courts are going to question, why have you not mediated? Why are you here? Yes, and I think what it addresses with the serving of the intention to mediate or invitation to mediate is if there are cases that are currently sitting in court, is go mediate while you're waiting for a trial date, or go mediate while you're waiting for a court date, or waiting to continue the process itself because judgment hasn't been given as yet. So I'm seeing in my country that we are moving, albeit slowly, we are moving towards mediation. And I'm sitting here preaching to the converted. So what I'm saying to those who listen to me, or wherever I go in terms of my media presences, or what I put out in terms of articles, is mediation should be the first step. And why? Because it puts you as a legal practitioner front and center in focusing on your client's best interests.
I mean, look, one point, of course, I've been trying to make is that we have to reach out to people and the user has to be involved and understanding the whole thing. So what is happening on that? How are you going to develop that culture of mediation, or are you developing it and at the community level with the schools, with the colleges, something on, I'm sure you're doing something there.
Yeah, so I do put out well, in terms of media, social media, I do put out articles and blog posts. I do advocate for mediation, collaboration. We do see life skills training in our schools in terms of communication. We will be, always talking to our children to use their voices. Our Children's Act brings out the voice of the child. So children are not, if they're subject to being silenced, they know they have a right to speak out. Um, in terms of South Africa itself, we have many advocates of mediation. So it is forefront in terms of what people talk about when it comes to negotiation. Is if we can't negotiate it, let's get a mediator to come and work with us or facilitate that negotiation. So it's not that it's hidden. It's there. And we're going to see a movement, and I'm hoping to see a movement. I'm just projecting it out there that we're seeing a movement towards more mediation,
I tell
less
you, look, I tell you
debate.
how I'm looking at it in terms of it progressing is maybe the right, it's like the right people that are out there. Who are those right people? People already trust some people in communities, in schools. These children have these people whom they go to help them resolve the disputes. People are doing it all the time within themselves. So I'm just saying that these people whom people have already identified as people you can trust to resolve your dispute, I want these people to come out and take it up as a profession. So how if and also at the same time this can happen if you do not regulate the profession, because you did speak about that aspect. I'm saying if you've got the right people who are coming forward, and I'm ultimately parties know they are the ones who want to appoint their mediator, so they know whom they want to trust. So let that happen. That movement, you want to upskill people, you want people them to do training and everything. You have institutions like you said, that can always happen. I mean, you can always go out and tell people, look, our mediators are this, are that. People will try, not try them, that's up to them. But I'm just saying that at this point of time, I'm seeing all over, it is a factory of creating this way. We will make a mediator. I don't see you making a mediator. I mean, I don't know whether you've ever seen any of the episodes of that show, Evolution of a Mediator. The whole idea was that the mediator is someone who goes through so much. There are experiences and everything. There are various aspects, and that person has a seed somewhere, and that seeds keeps growing as the person goes along. So I'm just saying we don't make a mediator. Let's pick up the people who have that seed and let's take them into the profession. But what you said about the lawyers and their role, let me tell you, of course, you would have heard it so many times, but I put it on my website, and this is the way I practice my law. So there are some people, and this Mahatma Gandhi, obviously South Africa connection. So let's put his words out. This part that I put there, he said that so many years back. So it's not alien to law of lawyers to look at this side. And how do they understand and when do they understand? I don't know. That's it, that whenever it happens. But lawyers and courts are not the only way of the whole dispute resolution world. There is lots more. I'm sure you've read it by now, so I mean you must have read it before also. Not a new thing, but if anyone else is watching, they might not have read this earlier. So let me put it out. So that's how it is. And of course, look, you will know me. I can go on and have conversations for a long, long time. So I'm sure there is you have short of time. So I mean, I can go on. Let me tell you. So, but we can end this here with your final words. How are you looking at the concept of the mediation developing in South Africa and the world, which you've already spoken about, but some final words.
Thank you. Well, mediation is a dispute resolution practice in South Africa. You know, it's not glaringly obvious, but we are moving towards evolving dispute resolution to make mediation a first step. I can see it through our core practices, and I can see it through how many mediators we are churning out and training. That there is an interest in a collaborative network of people who there is interest in creating that collaborative approach through the network of people I engage with. And it's going to grow. So, as young as our democracy is, 27 years old, we're going to grow this and change as we go along the cultural practices in South Africa to not just be our cultural practices in terms of our ethnicity, but our cultural practices in terms of our dispute resolution. So thank you so much, Vikram, for giving me this opportunity to talk about my experience in South Africa, talk about myself a bit and my opinions on things. And I appreciate it. So thank you for the time.
Thank you, Viraj. Look, I knew this session is going to be very interesting. Not that I had ever spoken to you before, but the fact that I had seen you in every other fora, I knew that this is going to be interesting, and it was very interesting. I'll introduce you to Isaac after we finish this session because he's from Ghana, so the African element we will pick up. So let me end this live session here, and thank you